Good morning, everyone. Good morning, Judge Easterbrook. Can you hear me?
Yes, indeed.
Great. Then we can get started this morning. Our first case for argument today is United States against Brett Brimberry. Ms. McDonald.
Thank you, Your Honor. May it please the court. The issue in this case is whether Mr. Brimberry was entitled to the entrapment instruction. When that instruction is given, the government bears the burden of proving beyond reasonable doubt that it was not entrapment. Mr. Brimberry presented some evidence, a requirement that this court has described as a low bar, of a lack of predisposition and government enticement. By failing to give the instruction, the trial court relieved the government of its burden of proof and relieved the jury of its duty as fact finder. This court should reverse. Both Mr. Brimberry and the government arguments center on two of this court's cases, Anderson and Sewell, of course with different conclusions. This case is like Anderson. In all three cases, though, the agents used photos of adults. They claimed they were adults from the beginning. They were all on hookup sites, and eventually each agent disclosed that they were 15 years old. In Anderson, nearly 300 text messages were sent over the course of 2 days, and the agent revealed the age after 38 of those 300 texts. Here, 89 messages were sent over the course of 3.5 hours, and the agent revealed the age after 2 hours in the 36th message.
Looking at our decision in Anderson, and I know we're focusing on the chat, similar to what was happening in Anderson, what could you drill us down to looking at these facts as to what showed that plus, something other than?
Certainly. Mm-hmm. The plus comes from the government's misrepresentations and promises that this was not a setup, that they would never do this, that they were not evil, which mirrors Anderson's comments, where Anderson also promised secrecy, said that that would be cruel and mean. I think something that's important here is in Anderson, this court noted that there were multiple breaks in the conversation between the agent and the defendant. Here, there was only one break. There was a 10-minute break when Mr. Brimberry responded to learning that the agent was 15 years old. After that, every single time Mr. Brimberry made any sort of comment, whether it was a reluctance or a fear of being a sex offender, the agent responded within usually the same minute. This was an onslaught of responses. In Anderson, the agent asked for sex 11 times over the course of 2 days. Here, the agent asked for sex by discreet and obvious invitations 8 times in less than an hour. There was really no time for anything to transpire. There was none of that moment that Anderson had. In both Anderson and here, it was the agent who pressed to solidify plans. Here, once the agent's age was revealed, Mr. Brimberry's comments concerned consent, the first question, getting in trouble, and agreeing to the agent's plans and desires. He actually never, after that 15 age was revealed, he never asked for sex. He never brought up any sexual activities. It was all the agent that actually did that. And I think that's an important fact that makes Anderson more like this case here. And in both Anderson and the present case, each time the defendant expressed any reluctance, the agent responded with statements like, I would never do that, that would be mean and cruel. In Anderson and here were, I'm not evil, that would be really shitty, I would never do that, all I can say is I would never do that. This court found that the entrapment instruction was warranted in Anderson because he expressed reluctance. Each time it was the agent who pressed for sex, nearly always promising secrecy. The agent repeatedly asked the defendant to come over, and also guilt, which I think arguably is not present here. In Sewell, on the other hand, That's markedly different. There, the defendant took an active role in arranging the encounter. I believe this court described it as keeping the discussion focused on explicit sexual activity. He requested the 15-year-old agent girl to describe what she wanted, what she liked for sex, asked for her to give him requests as to what he wanted them to do. Here, Mr. Brimberry simply agreed to what the agent suggested. There, the defendant pressed to solidify plans, and here it was the agent who did it. Importantly, this court distinguished Sewell from Anderson. In Sewell, there were 3 asks for sex by the agent over 6 hours. That is very unlike the 11 over the course of 2 days, but even more unlike the 8 that occurred in this short amount of time from 7:02 p.m. to 7:58. In Sewell, there were no repeated assurances to keep it a secret. There was no use of guilt, and frankly, there was no need for reassurance. As this court noted, the defendant was willing and ready, and seemed to relish in this court's language the idea of having sex with a 15-year-old. When we're looking at whether or not the circuit or the district court should have given the entrapment instruction, I think one thing is interesting to point out. First is we're sort of parsing both the government and Mr. Brimberry over how many times and how quickly it happened, whether or not that amounted to pressure. That is the role of the jury. Mr. Brimberry presented some evidence, more than enough evidence, that he was not predisposed to commit the crime.
But predisposed is a different question other than inducement.
Correct. They are intertwined in that the predisposition, most important factor, is the reluctance overcome by government persuasion. But he presented both, not only in his arguments before, in his response to the government's motion for limine, but also his testimony demonstrated that he was not predisposed and that that the pressure from the government was intense. When it's this close, this should go to a jury. As far as a policy is concerned, most cases don't go to a jury anymore in federal court, as we all know. And in this instance, Mr. Brimberry went to trial, and we want our defendants to go to trial. We want the defendants to have their defenses available to them, and we want the jury, not the judge, to decide what happens in that case. Mr. Brimberry was denied that here, and we ask the court to reverse. Thank you.
Thank you. Mr. Dean.
Thank you, Your Honor. May it please the court, David Dean on behalf of the appellee of the United States of America. I'd like to direct the court's attention to 2 timestamps in the chats which represent the proffered evidence, the only proffered evidence from the appellant in this case, as to what exactly the government agent supposedly has done to induce the defendant to commit this crime. Those timestamps are 7:40 p.m. and 7:47 p.m. 7:40 p.m. is the first time the appellant shows any modicum of what's been characterized as reluctance when he says, is this a setup? At 7:47 p.m., the appellant says, I'm already on my way. I think that's essential and frankly determinative in this case because as pointed out in the dissent in Anderson, that case, Anderson, is already frankly an extreme outlier in terms of the cases where this court has found evidence of inducement where the evidence was characterized as what's persistent or subtle persuasion as opposed to something more egregious like the use of epithets or threats or anything like that. When you're simply using so-called subtle persuasion, the cases outside of Anderson have been looking at months or weeks, and Anderson, of course, itself involves 2 days. This literally involves 7 minutes, during which the only thing the agent did was assure the appellant that it was not a setup. Now, simply that Mayfield is very clear that furnishing opportunity to commit the crime on customary terms is not inducement. And I don't know how the agent could have possibly furnished Mr. Brimberry an opportunity to commit the crime without denying that it was a setup. That's inherent in the nature of these sting operations. For these reasons, the government believes there's clearly no evidence inducement in this case. I welcome any other additional questions. Otherwise, the government will rest on its brief.
Thank you.
Thank you.
Ms. McDonald, any rebuttal?
Just in one point to the short amount of time where there were 5 promises made by the government that this was not a setup. I think in this case, the short amount of time and the amount of pressure and the quickness with which it was placed on the defendant by the government, giving him no time to react in really any way, is something that this court should take into consideration. It was a high pressure, very, very fast situation. Thank you.
Thank you very much. Our thanks to both counsel. We'll take the case under advisement and move to our second case this morning, United States versus Quentin Ferguson. Mr. Hillis, good morning.
Morning, Judge. May it please the court and counsel, my name is Daniel Hillis. I'm with the Federal Public Defender's Office and I represent Quentin Ferguson. Mr. Ferguson was sentenced as a career offender, but he shouldn't have been. The reason he isn't a career offender is that federal arson conviction that he had under section 18 USC 844I isn't a crime of violence. Under Taylor's categorical approach, the federal arson conviction is broader than generic arson and is not a categorical match. Federal arson requires the burning of property. It does not require, like generic arson, that the property be of another or that insurance proceeds are the purpose, that they're the effort of the unlawful burning.
Well, you're referring to the Model Penal Code definition, which is not uniformly used in this categorical analysis, is it?
No, it's one of the guideposts that we would look to, but I'm unaware of any notion of arson historically that doesn't touch upon the burning of another. So historically, it's well entrenched in what we would regard arson, and the collection of insurance proceeds are the way, of course, if it's not property of another, but you're burning your own property, that we would allow this to be distinguished from lighting a fire in a fireplace, smoking a cigarette, or lighting a candle, that there has to be some additional effort beyond the burning that would result in remuneration. We just don't have those things here as compared to the federal definition, or excuse me, statutory elements for federal arson 844I, Judge.
Why would we not use our definition in Gomez, where generic arson is intentional or malicious burning of any property?
Right, because that was not a very complete examination. That was not the focus of Gamez. So I think Gamez used that as a general notional sense of what arson might be, but that was not where Gamez was focused on for disposition. And for that reason, I would say we wouldn't look to Gamez, but beyond that,
What about
Gamez would be wrong.
that Gamez relied on in defining generic arson?
Sure, but Gamez then...
Meslevic.
Sure. Sure, yep. Also, not, again, focused on what we need to determine here. So if you want to look to those
No,
cases...
I'm asking why would we not apply that definition?
Because it's incorrect. Because it's not accounting for what generic arson is relative to what federal arson requires.
So would we have to overturn those cases?
I don't think so, for the reasons we stated in our brief, that we just don't think that Gamez and Mislevic were zeroed in on the issue like we need to be in this case. So if they are talking about something that is tangential and
Dicta.
yes, then of course we're not bound by it.
So it's your position that in both of those cases, the court was considering generic arson, but it was simply dicta.
It was considering generic arson, but
Okay.
I'm saying that the operative facts and what the disposition was in both of those cases wasn't focused on what we're focusing on here. So I just don't think that those cases, to the extent that they said in the course of the opinion what generic arson was, that they were defining for all times generic arson. I just don't think that those cases are helpful on this point. I think that we need to look at it now. And I think that if we were to look back to other cases that talk about what the understanding of generic arson is, and if we look at the historic information like the law review article for, I think, Professor Poulos that we cited in the brief, and the other materials, they will all, and I think Lefebvre as well, all identify the notions that we're focused on here, and that it has to be property of another, and that, or that it has to be with the effort to collect insurance proceeds. Absent those things, then we don't have arson here. We just don't have a categorical match.
Well, let's assume that we're willing to wipe the slate clean and start over, which is basically what you're asking us to do here, or at least amplify on the starting point of those previous
agree with that.
cases. What about the point that the definition that you're advancing based on the model penal code essentially makes the inclusion of arson in the enhancer statute self-defeating, because very few modern arson statutes are a categorical match to the model penal code? And we presume that Congress doesn't do self-defeating things.
No, not self-defeating things, but in this case, there's not alignment. And so while their efforts were imperfect, even if we know what their intent was, if there's not a categorical match, we would say there's a statutory fix for this, or there's something else that can be done. But we wouldn't look at this case and say, because we suspect what the intent was, that we should now look beyond the text, Judge. So I would say focus on the text first, of course, and then we look to what intent is, only if it's unclear, but the text here is clear. If I may detour slightly, because I do think this is important, I think I have put the cart before the horse in some regards, I do want to touch on standard of review. So to circle back to probably where I should have begun, it is important, in our opinion, to state our position. De novo review applies here. Yee versus City of Escondido, Billups, Bew, these are cases that are well established that tell us you do not forfeit arguments, you can forfeit claims. And the claim right along was that my client was not a career offender. I think that they argued the position differently, of course, in the district court, but nevertheless preserved the claim for the appeal such that we get de novo review. I think that we win regardless, provided that we can satisfy that there is an error and that is clear. The government, I think, has said as much in the footnote in its brief, that we would then have a different outcome here in the case if there's not a career offender application. But nevertheless, de novo review should apply and does apply here, based on Bew, based on Billups, and while the government is able to cite a case that's contrary to those, it comes later, and the principle of stare decisis remains alive and intact and is applicable here. So with that, I will reserve the balance of my time. Thank you.
Thank you. Mr. Temkin.
May it please the court. Good morning, Your Honors. Eli Temkin for the United States. This court should affirm Mr. Ferguson's sentence. Federal arson under Section 844I is arson under the Career Offender Guideline. Just briefly, I'll start with the standard of review. The government stands by its position that this court's review is limited to plain error because Mr. Ferguson forfeited the argument he's now trying to raise on appeal. Everyone seems to agree on the principles here, and the cases are consistent. You can argue a point in a new way on appeal without forfeiting it, but you can't raise a new argument in the first instance, and if you do, you're subject to plain error review. In this case, in front of the district court, Mr. Ferguson argued that Section 844I was not a crime of violence because the statute was not limited to fire-related damage, an argument under the Gamez case from this court. On appeal, he's now arguing that Section 844I is overbroad for a different reason, because it covers burning your own property, That's an argument that he didn't raise below. He had the chance to do that, and he said he didn't have any further arguments. That's on page 47 of the transcript. This case is on all fours with the Carr decision from this court from last year, as well as older cases that we've cited in our brief, such as McClellan, which predates the Billups case. Mr. Ferguson doesn't try to distinguish Carr, and the case is indistinguishable. In that case, the question was whether Illinois robbery qualified as a crime of violence under the enumerated offense clause. In front of the district court, Mr. Carr argued that the statute was overbroad because the Illinois statute was overbroad because Illinois accomplice liability is broader than under the generic offense. On appeal, he tried to raise an argument that the Illinois robbery statute was overbroad because of the mental state. This court said, that's a new argument, you forfeited it below, and we'll review, but only for plain error. The Billups case is distinguishable. In that case, again, applying the same principles, the court held that an argument wasn't forfeited because it was just a new twist on the existing argument in front of the district court. In that case, the question was about Wisconsin false imprisonment and whether it qualified under the residual clause. The argument on both levels was whether the risk of physical harm, whether the statute required showing a risk of physical harm or whether the offense could be completed through fraud or deception. And so that was the same argument on both levels. On appeal, the defendant introduced a new source of authority to support that same argument. In front of the district court, he argued based on jury instructions and the lack of an explicit element in the statute. And then on appeal, he cited also the statutory definition of without consent under state law. That was just amplifying the same argument, and that's exactly what the Supreme Court said in Yee, and a proposition the government agrees with. You can amplify the argument, but you can't introduce a new argument without forfeiting it. And just briefly to correct the record on this point, Mr. Ferguson in his reply indicates that the district court prevented trial defense counsel from switching attorneys to address this. Defense counsel never asked to have co-counsel address the point. Counsel asked if he could consult with his colleague, and the district court repeatedly let him do that. The district court did exactly what defense counsel asked for. All that said, plain error review applies, but this court should affirm under any standard, and I'll move on to the merits. The application of the categorical approach is a question of interpretation. There are a few ways to think about this interpretation, but they all lead to the conclusion that federal arson under Section 844I is arson under the career offender guideline. First, this court's case law understands Section 844I as such a good match for generic arson that the court uses 844I as the model, as the measuring stick by which to compare state statutes to determine whether they qualify. No federal court, to the government's knowledge, has held that Section 844I fails to qualify as generic arson, and Mr. Ferguson has not identified any case that holds 844I is not generic arson. The drafting history of the guideline illustrates why. The contemporaneous federal law is powerful evidence of what arson means, as this court noted in Mislovic. Congress enacted the Anti-Arson Act in 1982, which, for present purposes, defines arson under 844I. 4 years later, in 1986, Congress enacted the Armed Career Criminal Act, or amended it to enumerate arson as a violent felony, and then 3 years later, the Sentencing Commission imported that definition into the career offender guideline. That shows, again, as Ms. Levick noted, that those definitions are consistent, and that when the Commission enumerated arson as a crime of violence, it was using the definition that Congress had enacted just a few years earlier. The typical categorical approach analysis also leads to the same result. If you identify the generic definition and then compare it to the federal statute. First, as to the generic definition, generic arson is defined as the intentional or malicious burning of any property. And this court has repeatedly held that in cases like Gamez and Mislovic, and that's a widely accepted definition of arson. There is no requirement that the property burned be of another. Most states at this point have dropped any such requirement and had dropped it when the commission enacted the enumerated offense of arson. As the secondary authorities set out, Lefebvre and the Poulos article that we've cited, states have abandoned any requirement to that effect, and the Supreme Court in the Torres v. Lynch decision noted that many states no longer or do not require that the property burned be of another. As to the Metamorphosis article, Mr. Ferguson suggests in his reply that that article says that a felony arson conviction for burning your own property requires proof of insurance fraud. That's not what the article said. This is at page 298 of the article in note 5. The article says that states do sometimes define a burning for insurance fraud as arson, but that's not the only circumstance. That's not exclusive. That's not the only circumstance where burning your own property can be arson. The definition from Begay is not comprehensive or not exclusive as to what the defendant must intend. Begay holds, and as Ms. Levick explains, Begay holds that you need to have an element of purposefulness, but Begay gives examples of what that purpose might be. Those examples are not definitive. Ms. Levick says to construe those examples as definitive would be absurd. The Brown v. Carraway case, this court noted that Delaware second-degree arson would qualify as generic arson. In Mr. Ferguson's reply, he says that there's an affirmative defense if the property was one's own. The affirmative defense, in fact, has 3 elements stated in the conjunctive. The property has to be solely your own. Second, the burning has to have a lawful purpose. And third, the burning can't endanger any other person or the building. That essentially sets out the malice requirement. Section 840, that's all to the generic definition. 844I essentially is the same. There's a malice requirement. Burning your own property is arson, but only if it's malicious. McBride sets out examples such as burning your own wood. Mr. Ferguson hasn't identified any case applying 844I in this non-generic way that he's suggesting of burning your own property without malice. That would be arson under 844I. Certainly this case is not that, where Mr. Ferguson burned his ex-girlfriend's apartment in a fire that spread to an apartment complex, displaced 27 people, caused around $2 million of damage. And again, this reading that Mr. Ferguson suggests would be self-defeating. With that, the government asks the court to affirm.
Thank you.
Thank you.
Mr. Hillis, any rebuttal?
Well, I myself am not a slave to consistency. I think for the Department of Justice, it's important to adopt and pursue the same thoughts on E versus Escondido in multiple cases as they go forward in this court. So about 2 weeks ago in a 922G5 case, they themselves cited E versus City of Escondido, mentioned it, and now in Bruin, arguments were raised different on the appeal and for the first time, and that was okay in the government's view. So it seemed to me that they are taking a different position here today, and maybe it's just one hand not knowing what the other is doing, but I think it's important for this court to require the Department of Justice to be consistent, at least in its approach on these things, that they cannot benefit from E in one case and tamp down our efforts to press a point here in this case today.
And is the standard of review pretty much the whole ballgame here? Because plain error review for
Sure helps.
the head exploding categorical approach
I will
rarely plain to anybody.
Judge, as you know from all your experience, standard review is very often the difference maker in any case. And so regardless, if I think I can win on de novo review, I'll take that first and foremost, even though I think I could also win perhaps on plain air review. I would like de novo review here, like the government cited Yeet versus City of Escondido in the other case that I mentioned. Beyond that, the government, with its reference to what counsel was doing and how the lawyer asked that his co-counsel be able to argue, that's on appendix pages 43, 48 to 53. The government was itself allowed to have its person who was tapped to argue a particular issue, stand up and argue it. My client's lawyers had a similar plan in place apparently, where one was well versed in something and somebody was going to argue the point they thought for the government and they weren't allowed, or for the defense and they weren't allowed to. So we did not have the same fair opportunity to present this argument in any event, and that should be taken into consideration. And then finally, the last thing that I'll say is I'm a little confused by what the government was doing at the podium a moment ago. It seemed to be blending elements and saying how those things then describe state of mind. State of mind is different. It's separate from the elements. So I'm a little confused by the argument, and I don't think that this court needs to be. I think that we look at elements. We're not contesting malice in this case. We've abandoned any contention about malice. We're strictly focusing our efforts on malice. And for all the cases the government points to, it is replete every time we look. There are affirmative defenses that if it's your own property, you're not on the hook. It's not a criminal act. And so we can't distance ourselves from the essential requirements that do seem to mesh with what we are looking at here from the time of Begay and going forward, that there is a very solid notion that generic arson requires more than you simply burn property with malice.
Well, I get back to the question that I asked just a few minutes ago about whether that would make the Armed Career Criminal Act, from which the career offender guideline arises or copies, the list of offenses that qualify as predicates for the enhanced penalties, to include arson and define the generic offense in such a way as to exclude a great many arson statutes around the country. Not to mention the federal arson statute is a pretty significant argument to be advancing, because again, it would ascribe to Congress a self-defeating act, and also to the Sentencing Commission in adopting the same approach under the sentencing guidelines. And I haven't heard a really strong answer to that question yet.
Well, I'm going to try to answer it better this time around, and that is to say, self-defeating or not, if it's an improper effort now under the categorical approach, it just doesn't fly. That's the answer. So if we now look at, with the benefit now of all the years and the counterintuitive results that we have for the different applications of the categorical approach, we might say 30 years ago we never saw this coming, right?
Okay, that's fair.
Then I think this is where we are here today. That the elements are not a categorical match. We just need to look at Taylor, Begay, all the way through Mathis, and we've reached the right result.
Thank you. Our thanks to both counsel. We'll take the case under advisement and move to our third case this morning, United States against Ralph Thompson. All right, Mr. Hillis.
May it please the court, counsel, my name is Daniel Hillis. I'm with the Federal Public Defender's Office, and I am representing Ralph Thompson on this appeal. It's a very discrete issue, and it's not one that's unfamiliar to this court because it has held in United States versus Jenkins and United States versus LaDonta Gill that the AUUW convictions, when invalid, should not result in criminal history points and should not be the basis for any criminal history calculation. They should not also be relied upon by district courts because the convictions are invalid. You shouldn't be sentencing people based on AUUW convictions that have.
Mr. Hillis, if you could use real words instead of mystery initialisms, I think that would help us.
Very well, Judge. Let me dispel the mystery. The aggravated unlawful use of a weapon. That's the Illinois statute that Jenkins determined pretty easily, and LaDonta Gill again, that you just don't get points for that. So here, the district court.
Mr. Hillis, now I have a substantive question for you. I wonder whether your line of argument is consistent with the holding of the Supreme Court in Custis against the United States.
Well, Judge, I've modeled my whole brief on what the Seventh Circuit authority is, but if you would like to tell me.
But of
what
course,
Custis
the
is.
Supreme Court takes precedence.
Of course.
And the holding of Custis is that the validity of a state conviction may be challenged in federal sentencing if and only if the defendant contends that it was obtained without counsel. Other lines of argument are forbidden according to Custis.
Well, I suppose that would pose some serious concerns about how the court disposed of Jenkins and Gill, Your Honor. But
Yes, indeed it does. Jenkins didn't mention Custis. But
Nor
if
did-
there's a conflict between the Seventh Circuit and the Supreme Court, we do know which one we have to follow.
Oh, no doubt, but I'm not certain since government didn't cite Custis, Judge, so I would have to file a
I know.
J letter.
And it didn't cite Custis in Jenkins either,
Or in Gill.
which may be why the panel didn't cite it. But we are aware of Custis.
I don't have anything to say on Custis for the moment, Judge, but I will file a 28J letter as necessary. I would say, for the purposes of today, the government, of course, didn't argue Custis. I will have to do the 28J letter, and I'm not certain if Custis is dispositive. I take Your Honor's point, and I need to look into that further, but based on what we have as the Seventh Circuit authority, we would know what the outcome is, notwithstanding anything that may sort of upend us here with Custis.
Well, even given Jenkins, you have a serious problem that this issue was never raised in the district court.
Well, I don't believe it was raised in Jenkins either, Judge. For that matter, it wasn't raised in LaDonta Gill. So I'm not certain that that is the barrier that would prevent us from a win here. They both won those other cases, of course. So we'd be in a similar circumstance, Your Honor. That's our view. And so,
You do realize we have a brand new en banc decision on when issues can be raised sua sponte by the court. That's United States against Page, which of course takes precedence over Jenkins.
yeah, I've been on the wrong end of sua sponte en bancs before, Judge, so it could happen again. But for today, I'll only say that I think that we're good on Gill and on Jenkins. So beyond that, I couldn't predict. Now, as final matters go, how are we certain that this did come to the attention of the district court? And we can look to the record easily enough on this. Appendix is page 5, 7, 27 to 28. We know the district court specifically referenced the number of convictions. We have the government's sentencing memorandum where they highlighted in a very brief sentencing memorandum about the significance of the aggravated unlawful use of a weapon conviction. We know that the PSR included the points and the district court adopted the PSR. So there's no doubt that the information was in front of the district court and the district court relied on the aggravated unlawful use of a weapon conviction
How
to
was
impose
Mr.
sentence.
Thomas prejudiced by the use of this conviction?
It'd be similar to Miller, Your Honor, a case that we cited in our brief, where the wrong number of felonies is itself a basis for relief in Miller. So if you say that a person has 5 felony convictions, but they only have 4, that's a difference. That's an important difference, the number of felony convictions. And here, this would be 1 less felony conviction, so similar to that, where the district court in this case says he has, I think, 9 felony convictions. We'd have 1 fewer, and consistent with Miller, we would say that's a basis for remand.
But it's not a guidelines error. The range is the same no matter what.
Entirely right, Judge.
But this is an argument directed at the 3553A analysis of the judge, the sentencing factors.
More so to the due process, the right to be sentenced on accurate information. And so this is an invalid conviction, and under this court's due process precedent, we'd say that that's our stronger hook.
Well, either way you look at it, there's still a prejudice requirement. So the weight that sentence in the sentencing transcript bears on our analysis is the significant question.
Sure, and I'd only point you back to Miller, which, again, it was sufficient in Miller and it would be sufficient here. I wouldn't see where the breathing room is between those two cases. I did love how the defendant in Miller actually stood up and said that that's incorrect, Judge, I only have this many convictions. We didn't have that, but we've got otherwise the same core of facts that allow us to get relief here per Miller.
Thank you.
Okay, I have nothing further, thank you.
Mr. Weir.
Good morning. May it please the court. Matthew Weir for the United States. I'm going to answer Judge Easterbrook's question that I don't have any familiarity with Custis either. And I apologize.
This seems to be a problem in cases of this kind. We have holdings by the Supreme Court, which the Seventh Circuit has, it seems to me, conflicted with without even bothering to discuss, because the parties haven't discussed the holdings of the Supreme Court. That is a problem, don't you think?
I do, yes, Your Honor. And similar to Mr. Hillis, I don't have any knowledge of that case, so I can't speak to it. I take Your Honor's word on the holding of it, and if the court would ask of it, I would be glad to supplement as well, as Mr. Hillis suggested. But I don't know that in this case, Your Honor, that's necessary, because I don't believe that the plain error standard is met, and I think it's pretty clearly not met. There is clear error. Those 3 points for that conviction should not have been in the PSR, but they did not affect the substantial.
So are you conceding the opposite of the Custis holding? To say there was error is to say, I think, that you think the Supreme Court was wrong in Custis. That's a little difficult.
I would say, Your Honor, following purely the Seventh Circuit, that would be the government's position. I cannot argue Custis with any knowledge, but I believe that the review in this case, assuming arguendo that there was plain error, would fall on prejudice, which is simply something that the defendant cannot meet. It's a remarkably demanding standard, as this court has stated before, and essentially it boils down to, is there a reasonable likelihood that anything about the defendant's sentence would change if that information had not been before the court?
I'm somewhat concerned when we're looking at the standard of review. I know the parties have agreed that it is plain error. Here, the argument that I'm hearing this morning is a little slightly different and focused more so on how did the judge, looking at 3553A factors, consider this 9th conviction, which was invalid. And when we look at the sentencing transcript in context, the ruling and the reliance on this 9th conviction comes out during the ruling. Why would that not be de novo review? And why would we not be under de novo versus plain error review?
Because, Your Honor, the error was in the PSR.
And so we're not that's what I'm suggesting. What I'm hearing is a shift. We're not focusing on the PSR calculation because the calculation in the PSR did not change because the career offender classification never changed. And what I'm hearing this morning is that the defendant was denied, due process in the sense that this 9th conviction that the court considered when ruling in imposing a sentence was the issue because the 9th conviction was invalid.
It's true, Your Honor, that generally, if an error comes up for the first time in pronouncing sentencing, then a contemporaneous objection is not required to preserve that. However, this error stemmed from an unobjected to error in the PSR. And since there was a more than adequate opportunity to object to that error, the review becomes for plain error overall, because the error was in the PSR. It should have been obvious to all the parties, but defense failed to raise it. So that error stems from the PSR, which requires plain error review, since it was not objected to contemporaneously. And, Your Honor, I would like to just briefly turn to what actually occurred at the sentencing hearing here. I would take a little issue with the idea that the court relied on this plain error, the 3 points, in sentencing, at least not 3 times as suggested by defense. Yes, the court adopted the PSR with no objections. The court then calculated criminal history points, but the court correctly calculated the guideline range, which is one of the fundamental purposes of the sentencing hearing. The court must correctly, obviously, calculate the guideline range. And once it calculated the correct guideline range, it did not ever alter its analysis, even though the defendant requested that the court consider the non-career offender guideline range. So there's no reason to believe that some change in the non-career offender guideline range would have affected the court's sentence in this case. The closest the court came to a explicit reference to this conviction was when it calculated the number of convictions. Even then, though,
But that's an incorrect description of what happened at the hearing, because it is during the ruling of the sentence. He says, now I'm getting ready to impose a sentence.
correct, Your Honor.
And during those 3553A steps, one of the reasons offered for the sentence was the 9 convictions.
That's correct, Your Honor. However, I think the context of the reference to those convictions is important, because right before that, the sentencing court referenced the career offender guidelines and the fact that this was the defendant's 3rd drug distribution conviction in federal court, directly referenced those convictions. It then went on to state you have 9 adult convictions. Should have been 8. But that is then also in the context of what the court said immediately after, which was a reference to recidivism and a failure of deterrence, even though he has all of these convictions. So I don't believe the specific number was the focus of the court's statement in that case. I believe it was a reference to an extensive criminal history. And, Your Honor, one last thing I would point out is that the reliance on Miller in this case is, in the government's view, inapposite, because Miller was a de novo case. It was a case that was preserved during sentencing because the defendant did object. And so the only thing that had to be shown in that case was an error that was relied upon. There was not a prejudice element in that case. And I think that's an important distinction from this case, because prejudice is the main driving factor here for remand, and there just was no prejudice. And with that, if there are no questions, I'll rest in my brief. Thank you.
Thank you. Mr. Hillis, anything further?
I hadn't thought of it at the time, but it seems that waiver would now be a problem with Custis. If the government were to try to assert that Custis would somehow be its get out of jail free card, that it would present a waiver problem. This would be a can of worms perhaps the court wouldn't want to have to get into. In light of Jenkins and Gill, if we're to instead confine our decision-making to those cases and to Miller, I think that the government's hard-pressed to come up with a reason why those cases would be decided as they were, in this case, should turn out differently. So in Miller, even if it is de novo review, ultimately relying on incorrect information is itself a due process violation. The result is presumed prejudice because we don't know how the incorrect information caused the sentencing determination perhaps be different. And so that's why in U.S. versus, the Welch case and the other cases that are similar to it. I think Welch was 1984. But all the cases that have come since that time, Corona Gonzalez, we don't require prejudice in the sense that the government is asking this court to do that now. We look instead and say, was there incorrect information? Was it relied upon? Because we can't pick apart the judge's thoughts to say how that impacted the sentencing decision.
I'm not following. Due process errors are subject to, most due process errors are subject to harmless error review on de novo review, or here review for prejudice on plain error review.
Corona Gonzalez did not require some further analysis beyond that. In Corona Gonzalez, the district court said that the individual returned to the United States after being deported, after being removed, came back in for the purpose of selling drugs. There was no information to support that, and it wasn't required that some additional prejudice be shown. The incorrect information was sufficient to warrant the remand, Judge.
I'm not sure that's the right precedent to follow then, because there are very few presumptively prejudicial errors, whether constitutional, statutory, or discretionary. That's structural errors only.
But the Welch case itself was robbery versus armed robbery, and the misdescription of it as an armed robbery led to the relief in Welch. So I think that the references to the cases support the proposition, Judge, at least so far as the Seventh Circuit authority goes that I'm citing. I think it supports what I'm contending here at the podium. If it's different, I suppose I could read that in opinion here before long, but nevertheless, Welch was armed robbery versus robbery, and in Corona Gonzalez, it was about the purpose for the individual in coming back to the United States. Here, we have something that is akin to Miller, though. So we have the number of felonies in Miller being at issue here. We have the number, rather there, we have the number of felonies here being off in each case. Like in Miller, this case should be remanded for resentencing. Thank you.
Thank you. Our thanks to both counsel. We'll let you know if we need supplementals on Custis or anything else, and the case is taken under advisement. We'll move to our fourth case this morning, United States against Anthony Moneyham. Ms. Sostock.
Good morning.
Good
May
morning.
it please the court, Aaron Sostock for defendant appellant Anthony Moneyham. This case is the appeal from Mr. Moneyham's sentencing following the revocation of his violation of his supervised release, and we are appealing just a very discrete issue in his sentence. The issue we're appealing here is that the district court's oral pronouncement and the written judgment regarding his sex offender treatment provision in the supervised release were in conflict, and thus they need to be, the written judgment needs to be vacated or sent back for reconsideration.
Counsel, I have a question for you that you may deem left field, as in the last case, but why does the oral pronouncement control over the writing when supervised release is being revoked?
Well, here the judgment was to impose a sentence on Mr. Moneyham, and my understanding is that in any judgment, the oral pronouncement controls over the written.
Why?
Because
Why? That's a doctrine dealing with sentencing in the original case. We're here dealing with revocation of supervised release. And what the supervised release statute says is that the term has to be imposed in writing. That's 18 U.S.C. 3583F. That seems to say that it's the writing that matters when supervised release is being revoked. There's no discussion in the briefs of 3583F, and that worries me.
Yeah, I agree that was not briefed, but I would say because there was an oral pronouncement, I'm not aware of a situation where the oral pronouncement doesn't control over the written judgment.
Where does that rule come from as applied to supervised release? You see, I worry, you could tell from the previous case, I worry about things that happen when the lawyers don't contest a foundational issue The Court of Appeals issues an opinion, and it then gets cited the next time as having established some proposition that the lawyers never dealt with, never contested.
Well, here's what I would say is that although this does include a condition of supervised release, we are still appealing a portion of the sentence. And the law that I am aware of,
It was something imposed on the revocation of supervised release. It's not a separate sentence for crime. If it were, we would be having double jeopardy problems, right? The rationale for this is that the judge is deciding how much of the original sentence is to be served.
there was also, though, a finding of guilt, and then a new sentence was imposed on Mr. Moneyham at this revocation hearing. So that is where that's why I'm relying on the normal presumption that the oral pronouncement controls. And I will also say that the case that
Is there
the
a
government-
distinction between the written statements that were provided to Mr. Moneyham before the hearing? Was that different than the written judgment?
The only written statement provided to Mr. Moneyham before was that he should complete a sex offender treatment evaluation. He was not ordered to actually comply with the treatment, just to be evaluated, which I believe is a difference from what was in the written pronouncement, which said that he must comply.
No. I'm talking about the written statements that were provided to Mr. Moneyham by the probation officer prior to the revocation hearing.
That is the only. There was only one statement in those written
Conditions?
Yeah, conditions. There was no actual additional full PSI done prior to the sentencing. So there was literally just one sentence referring to sex offender treatment. It was that he should be evaluated for it, which is not consistent with what was in the written judgment, nor was it consistent with what was in the oral pronouncement, which spoke about understanding why he was caught up in these incidents that he was caught up in the jail. So, and the difference was mainly between the scope of the treatment, and contrary to what the government did try to argue, the written judgment did not give more specificity as to what the sex offender treatment was. It actually added additional conditions, which were of physiological testing and mandatory use of any prescribed medications, neither of which Mr. Moneyham had any opportunity to object to or be advised of prior to the actual sentencing hearing. And that also is related to the issue of waiver, that the government tried to say that Mr. Moneyham had waived this issue by not raising it in the trial court. And I will just address that briefly, in that Mr. Moneyham's only argument on appeal is that the written and oral pronouncement do not comport with one another, and therefore that is not something that he could have preserved in the trial court because the written judgment had not been entered yet. There was no opportunity for him to object to that. So for those reasons, we're going to ask that this court either vacate the written portion of the judgment which imposes those two additional conditions, or alternatively remand this case back to the district court to correct the issue and make sure that the judgments are in agreement. Thank you.
Thank you. Mr. Kerwin.
Good morning, you may please the court. Brian Kerwin for the United States. Judge Easterbrook, I'll start with your question. And I take your point, and I think it dovetails and virtually mirrors our waiver argument here. And our overarching point that we tried to bring across in the brief is that the oral condition here was the written condition. Contrary to counsel's response to Judge Pryor's question, and I believe this is at docket 75, probation's violation report attached a set of conditions that it recommended that Judge Coleman impose. And at the hearing, starting on page 24, Judge Coleman began imposing each of those conditions with one exception, and that was condition number 2 in the special conditions section. She used shorthand, sort of paraphrase reference to each of the conditions that probation had provided in writing, and she was not imposing oral conditions or in any way modifying the conditions that were set forth. She was simply providing the defendant either a reason or a directive to look at the writing in front of him. She uses that phrase specifically on page 24 of the transcript. At page 26 of the transcript, she starts reading the mandatory conditions. She references the discretionary conditions one by one, beginning on page 28. She does the same things for the special conditions, including special condition 9 that's at issue here, beginning on page 31. Judge, I will confess that I hadn't thought about whether there would be a due process or a notice problem if she had actually imposed new conditions at the hearing and then contradicted those in writing. I intuitively think that probably would present a viable argument.
What would due process have to do with this?
But Judge, just maybe this is too generous to defendant's rights, but I think if a defendant came to a sentencing on a supervised release violation and the court told him to follow certain conditions and those were contradicted in writing, you would have something akin to an irreconcilable conflict.
Under the statute, under 3583F, the writing controls, not any oral statement. Now, are you suggesting there might be a constitutional problem in the statute? It's a very strange argument for the lawyer for the United States to make.
I'm confessing that my intuitive reaction to your question initially would have been in that counterfactual, where the oral conditions were contradicted by what the judge then imposed in writing. The defendant may have a colorable claim. That's not what we have here.
Why? It happens in civil cases all the time. The judge says things in open court, and then he or she enters a judgment, and it's the written judgment that controls.
Perhaps you're right, Your Honor, and 3583F says that all of these cases that the parties have cited in the briefs concerning sentencing and notice and things of that nature just don't apply at supervised release.
No, look, I know you haven't done the research on this, but back in the 19th century, before there were such things as pre-sentence reports, the justices of the Supreme Court were worried that the judge would say enough at sentencing that the defendants would know what it is they had to tackle or contest. Whether that's true in a world with elaborate written reports from the probation office, one may doubt. But my question was whether this old, very old common law rule had been extended to the revocation of supervised release. And obviously neither side has thought about that.
The government hasn't, Your Honor, but I'll just come back to my original point, was that here the written judgment can't conflict with the oral judgment because they're one and the same. The judge was not imposing oral conditions, it was orally imposing the written conditions that the defendant had in front of him. The transcript makes that plain. And so there is no inconsistency, and even if there were, it would not be one that would mandate any reversal, because at most the written condition provides more specificity than the oral pronouncement did. So unless the panel has any other questions for the government, I'll ask that the court affirm the judgment and sentence of the district court.
Thank you. Ms. Ostock, anything further?
Actually, I have nothing further after reviewing my notes.
All right, thank you very much. Our thanks to both counsel. The case is taken under advisement. And our fifth case for argument this morning is JER Creative Foods Concepts versus Creative Pack Foods. All right, before we proceed with that argument, and I know one of our attorneys is going to be online for this argument, we'll take a brief recess and be back shortly. We'll wait for him. All right, we are back in session with JER Creative Food Concepts versus Creative Plant Foods, and everyone is present and accounted for both in the courtroom and online. Mr. McElnay, is that how it's pronounced?
Yes, Your Honor.
Yes, please proceed.
Thank you. May it please the court, Bruce McElnay for the plaintiff appellant. I'd like to begin and kind of get through the issue of the statute of frauds. As the court is aware, we are relying on the Cloud Corp versus Hasbro case, in which the court said that the purpose of the statute of frauds is to avoid creating tribal issues about whether a contract even exists on say-so alone. And in that regard, I would turn court's attention to this is in the separate appendix beginning at page 8, these undisputed facts regarding the formation of the contract. My client sent the draft contract to the defendant in November of 2014. On December of 2014. On January 19th of 2015, Mr. Cochran, the president of the defendant, sent it back with this note. Attached is the contract with highlighted and yellow spots of changes. There's nothing major other than the areas that we thought needed more clarification. Later that day, my client's president followed up saying, we got this invoice for the build out. We didn't expect that until we had a contract. The president of the defendant responded, I sent the contract an hour ago by email. The point I'd like to make is in preparing for today, I noted that it seems as though that the defendant's argument is in that email, Mr. Cochran didn't separately type his name or somehow otherwise include his name underneath the text of the email. I think that given the ubiquitous usage of email and commerce today and the realization that receiving email saying it's from a specific person, such as Mr. Cochran in this case, is the equivalent of a signature in previous days, and in fact may be better than simply typing one's name in there, in that it's generated by the computer based on whose system it's being sent from, as opposed to something that could be forged from somebody else. So I submit that the statute of frauds is not an impediment here. I also wanted to emphasize the factual background that I went through in this case, specifically because I think it's important in understanding the context in which we're arguing the economic duress is something that goes back to the reliance that my client placed on the defendant in making the decision whether to do business with them in the first place. And why that was such an important decision is because, unique to my client, and at least in my 40 years of practice experience, they were taking their equipment, my client's equipment that they own, and putting it into the defendant's facilities as fixtures which it was expensive, showed a great deal of reliance on the defendant in maintaining and that equipment and so on. And for the economic duress point, most importantly, gave the defendant exclusive control over that equipment and the means to manufacture my client's product. And that is the background in light of which, when the time came that the parties parted ways and the defendant said, you got to either sign this agreement or we're not going to send you any product anymore. I think we come under the, it really falls under the concept that there was a monopoly situation imposed, temporary, albeit, very similar to the Austin Instrument case cited in the briefs. And the counter arguments that, well, they could have sued, they had alternatives. It's all disputed in Mr. Freed, my client's president's affidavit, that we had alternatives. It's not, we're here on a summary judgment issue. Our contention is that Mr. Freed's testimony is sufficient. It's not necessary that we prove that we'd ultimately succeed in the trial court, but that there's a triable issue of fact. And I submit that the record establishes that. And unless there are questions now, I will reserve the rest of my time.
Thank you. Mr. Whitney.
May it please the court, counsel, Zach Whitney from Konerman and Kalis, appearing on behalf of Creative Pack Foods. As far as Creative Pack Foods is concerned, Judge Connolly, the district court, got this right. There is no economic duress here. For economic duress to be found under Wisconsin law, there's a number of elements that need to be there. One of those is that there would have to be evidence, proof of a deprivation of unfettered will that Creative Pack Foods was forcing essentially upon Golden Select, and that didn't happen here. The transition agreement was signed in March of 2022 after almost 2 weeks of negotiations. And you can see the court, I encourage the court to look at the negotiations which went into the transition agreement. It's attached to the complaints as I believe it's 1-3, 1-4, 1-5. In any event, they're exhibits to the complaint, and it shows the back and forth. So Creative Pack Foods or has an initial proposal for the transition agreement. Remember, this was a business relationship. It had been going on for 7 years. Eventually, it was going to come to an end. And here's the parties negotiating how it is it's going to come to an end. And they present this proposal to Golden Select. Golden Select responds with their own proposal, agreeing with many of the items that were in Creative Pack's proposal, but also adding some new ones. They added some purchase orders. They added an alternative production provision in case raw materials and packaging materials, ingredients were not on site during the scheduled process of producing Golden Select's product. And they also negotiated an extension for when they would need to have all of their equipment out of Creative Pack's facility, the Elmwood facility that was closing down. They negotiated the deadline by which they needed to pay a deposit that would ultimately fund any fees or fines that Creative Pack would impose if their equipment was not removed from the facility. And in the third iteration of that, the iteration that both parties signed, that everybody agrees both parties signed, Creative Pack accepts those changes as well as some additional changes. So this was definitely a situation where the parties came to the table. There was a back and forth. This wasn't take it or leave it from Creative Pack Foods. This transition agreement was the product of a well thought out method by which the parties could cease doing business together. Another element that needs to be shown in order for a court to find economic duress is that there has to be some sort of disproportionate exchange of values. In other words, essentially that Golden was getting, Creative Pack was getting something for nothing. And not only is that not here, it wasn't even argued in Golden's brief. They don't even make any effort to do so because it's very clear that the exchange of values here was proportionate. Creative Pack did end up producing an awful lot of food product for Golden during that transition period. In fact, that was part of Creative Pack's counterclaim, which is not at issue in this case. It was awarded by the court. They produced enough of the food product, presumably to get Golden through the safety period until it found a new co-packer. At least as the court can see from the record, there is no evidence that Creative Pack failed to produce enough product for Golden until they subsequently found a new co-packer, and they did subsequently find a new co-packer. So there is no disproportionate exchange of values here, and of course, I think where Judge Connolly spends a lot of time too in his decision is discussing the final factor or element of economic duress, which is no adequate legal remedy, and he points out the fact that really October of 2021 through May of 2022, June of 2022, there's an eight-month time frame where Creative Pack has advised Golden that it's going to be shutting down the facility that has Golden's equipment and that Golden would need to remove its equipment from the facility. And from that time frame, Golden really has three options. They can, if they believe that that packing agreement, the unsigned packing agreement, nobody signed, they believe that that in fact is a valid contract, they could have sued to enforce it through either injunctive relief, specific performance, however they wanted to do it. They could have negotiated the transition agreement, which they did, and again, this was a give and take negotiation, or they simply could have packed up and found a new co-packer. Now, Golden maintains in their affidavit that they couldn't locate a new co-packer. What we know without a doubt from the record is that prior to Creative Pack Foods being Golden's co-packer, Golden had a different co-packer. And after Creative Pack Foods ceased being their co-packer, Golden had another co-packer. So there are co-packers clearly out there which could produce Golden's product. Golden chose to do number two. Didn't choose to seek relief from the court. They chose instead to negotiate the transition agreements, and they did negotiate the transition agreement. Creative Pack performed as it was required to do so under the transition agreement. I do want to, and I know the statute of frauds issue was discussed by counsel, just briefly, yes, it's Creative Pack's position that there needs to be signatures. Under both the common law and the UCC, there needs to be signatures, and there's not signatures here. And no, we're not saying they need to be wet ink signatures. Electronic signatures would be fine. A mark that you make on a machine when you're using your Visa at the grocery store would be sufficient. There's nothing here. There is no signature that either party put on that packing agreement, and as a result of that, Creative Pack Foods maintains that the statute of frauds was not met. The last item that I wanted to briefly touch on, and I think that this is actually a big issue, alternative grounds why it is this court should affirm Judge Connolly's decision, is the issue of damages. So this case was filed in January of 2022. Discovery occurred over the course of it's filed in January 2023. Discovery occurred over the course of the year of 2023. Come January of 2024, based upon discovery, it came to Creative Pack's awareness that there's no damages here, that Golden simply cannot prove damages. We'd ask interrogatories, they're all in the record. We'd ask for document production. We asked for evidence that Golden suffered damages, and Golden presented absolutely nothing. So Creative Pack moved for summary judgment on all of the grounds that are before the court today, the release, as well as the statute of frauds and the issue of damages. Summary judgment briefing ended in February of 2024. While summary judgment was being briefed, Golden at no point in time presented evidence of damages. And they continued to not present evidence of damages all the way up to the point in time that the court ultimately decided summary judgment some months later. There is no evidence of damages in the record today. And as this court has said many times over, summary judgment's the put up or shut up moment. If you're a claimant, you have to prove your damages. And if you can't prove damages by the summary judgment stage, it's time to get out. Golden has never proved that they've been damaged by anything that Creative Pact did. Frankly, I think the reason's obvious because there were no damages here. But that being said, at the summary judgment stage, they needed to present evidence of damages. They didn't do so. That is reason enough for this court, despite the other legal reasons, reason enough for this court to affirm Judge Conley. Barring any questions from the court, Creative Pact Foods is happy to rest on its brief. Thank you.
Thank you. Mr. McElnay, anything further?
Briefly, in terms of negotiation, in coming up with the transition agreement that included the release of contract claims, what's disproportionate is what they gave was already due under the contract. And so there wasn't any additional benefit to my client from that. And in exchange, what they extracted was a release against all claims that could be brought under the contract. The issue of damages, let me touch on briefly, because it relates to the disparate bargaining positions here. My client, it's in the record, it's part of his affidavit, is a two-person show. And we moved the district court for more time to produce that evidence. We're ready to produce it. The court came out with its decision, and because it decided on the economic duress issue, deemed our motion for more time to produce the damage evidence moot. And we would like the district court to be able to hear our argument on that point and rule on it at that stage. It's really part of the district court's discretion and management of its docket kind of issue. And with that, I have nothing further unless there are questions.
All right, thank you very much. Our thanks to both counsel. The case is taken under advisement.
Thank you.
And we'll move to our sixth case this morning, Valerie Thomas versus LNNV Funding LLC and Resurgent Capital Services. Mr. Newberger.
May it please the court, Manuel Newberger for the appellants. Before I begin, I need to apologize. I'm visually impaired. If I have to refer to my notes, I sometimes have to get very close to my screen. No disrespect is intended.
Thank you.
Every case is supposed to begin and end with subject matter jurisdiction. This court's decision in Ewing in 2022, in Freeman in 2024, and last week in Wood all support the conclusion that Ms. Thomas failed to show that she had Article III standing necessary for the court's jurisdiction. In addition, a case decided last Thursday in the Sixth Circuit called Lawless versus T Financial would also support that. Lawless dealt with traceability, but I think it also supports the way this court has gone. What this court did in Ewing was recognize that publication requires more than that someone say something that is heard by another. It requires that the statement at issue that's allegedly defamatory be understood. It is a low bar, but it is a bar nonetheless. And when you take that in conjunction with the Supreme Court statement in Lujan, that at trial, at all stages of the litigation, the plaintiff must establish standing, and at trial, the plaintiff must deduce evidence showing that she possesses standing, what we see is that standing, starting with the pleading, is an IOU that the plaintiff writes. At each stage of the proceeding, the plaintiff has to show that there's something in the account. And when it comes time for trial, Lujan tells us the plaintiff has to cash that IOU. Ms. Thomas failed to do that. What I find remarkably admirable is what this court did in Ewing. This court set a very low bar for consumers. You did not create a burden where consumers have to go out and hire expert witnesses to show their injury. Both of the plaintiffs in Ewing showed their injury by showing that there was a change in their credit score between the time of the reporting of not disputed and the time it was reported as disputed. Ms. Thomas made no such showing. She would have this court simply assume that because someone saw her report, that had an impact that would give rise to injury. And the case law does not support that. She did not show a single-digit impact on her credit score. Ewing is remarkable in that respect. FDCPA cases tend to be small-dollar cases. The burden of hiring expert witnesses might be severe for a plaintiff. But all that this plaintiff had to do was go out and get 2 credit reports, admissible with a sponsoring witness, and show that there was a change in her credit score. She did not do that. And I would argue that the failure to do that is clear evidence that no injury actually existed. Now, there is another factor. This case was brought under Section 1692E8 of the FDCPA. That section provides that it is a violation to represent or threaten to represent to a third party credit information which is known or which should be known to be false. In this case, the letter at issue differs from the letter in last week's case. In last week's case, Mr. Wood said that his letter should be treated as a dispute. He's actually the author of the letter in this case, but in this case he didn't use the word dispute. He asserted one very narrow factual contention. The amount reported is not accurate. And what we know happened at trial is that at trial Ms. Thomas testified that she agreed on the amount due and that the balance reported was the exact amount that was left after you took her charge-off balance and subtracted her post-charge-off payments. Her testimony shows that the statement was not false. So there is no injury. And one of the things we can see here, and I just want to be clear, unless the court has other questions for me, is this. We can see the difference in a case like this between damages and injury. Under Ewing, Ms. Thomas could have shown injury from an Article III perspective simply by showing that her credit score had changed, even by a single digit. Damages still might not be present. She might have shown that she possessed standing, but not shown that she was denied credit, not shown that she paid a higher interest rate, completely failed to show any adverse action in the language of the Fair Credit Reporting Act, but she would still have possessed standing.
I don't think Ewing requires a change in credit score.
It does not, Your Honor. It requires a showing of understanding. And it does it in the context of what publication means. It's sort of like if I walked into a room where everyone spoke nothing but English and defamed someone in Urdu or Tagalog and they don't understand it. There's no defamation that occurs. What Ms. Thomas did not establish at trial was that anyone understood the trade line at issue. And I only use the credit score because that was what my friend Mr. Phillips did in Ewing, and he was able to very ably show that there was an injury. The bar is so low that if we look at the Mack case, $3 of expenditure is enough to show an injury. In Ewing and the companion case that was heard with it, a change in the credit score. Something in an E8 case must show that someone understood what was allegedly defamatory, but of course in this case, the record also shows that the statement was not false. Respectfully, Ms. Thomas had no injury, she showed no injury, and the court should reverse and remand this case to be dismissed for lack of subject matter jurisdiction. I'll reserve the rest of my time for rebuttal unless the court has questions.
Thank you.
Thank you.
Mr. McCormick.
May it please the court. Good morning, Your Honors. My name is Seth McCormick, and I represent Ms. Thomas. Last week in Evans, for the third time, this court clarified. Last week in Wood versus Secured Credit Services, this court reiterated for the third time that the failure to inform a credit reporting agency that the debtor disputed his or her debt will always have an influence on the debtor, as the information will be used to determine the debtor's credit score. And this court has consistently held that a failure to include a dispute on a credit report bears a sufficiently close relationship to the common law tort of defamation, which provides an intangible injury to a claimant. Ms. Thomas has done this at every stage of the case. She pled it. At summary judgment, she demonstrated with actual credit reports that the debt was not included in the February credit report, and it wasn't.
Counsel, my worry is not either the pleading or summary judgment, but the trial stage. Judge Bucklow entered an order precluding the plaintiff from showing damages, from showing injury, on the ground that the plaintiff had not produced any evidence of injury whatsoever. And my concern is that the Supreme Court held in the Defenders of Wildlife case that standing has to be shown at every stage, including trial. So given Judge Bucklow's order and the failure to even try to show injury at trial, don't you have a problem under Defenders of Wildlife?
I don't believe so, Your Honor. My understanding is that, I guess as an initial matter, the defendant stipulated to the standing at trial. The stipulation.
You can't stipulate to standing. It's impossible.
Well, and my point is that they stipulated.
It doesn't matter what the parties agree. Article 3 requires proof.
Right.
Defenders of Wildlife says that there must be proof at trial.
And they admitted at trial that there was a stipulation, and they admitted that defendants received plaintiff's dispute letter on February 1st. On February 3rd, defendants reported plaintiff's debt to TransUnion, but failed to note that the debt was disputed. The next reporting cycle for plaintiff's account closed on March 3rd, 2021. At that time,
none of this has to do with injury.
It has to.
What I'm really asking you to discuss is the effect of Judge Bucklow's bar order, the ruling in limine, and how that interacts with the Supreme Court in Defenders of Wildlife.
Well, the FDCPA, as an initial matter, the FDCPA does not require a showing of actual damages.
Look, the way you deal with my question, which concerns Judge Bucklow's order and the Supreme Court's holding, is to address Judge Bucklow's order and the Supreme Court's holding.
Sure. Judge Bucklow's order was that we had not we had, at the motion in limine stage, had not produced enough evidence to demonstrate actual damages. That was her holding. She did not hold that she had not, that Ms. Thomas was not affected at all. And Judge Cummings actually points that out in some of his rulings, in his determination about what evidence to permit at trial and what evidence not to permit at trial. He stated, that based on her ruling that the only evidence he was going to permit was was related to the 3 factors of statutory damages. I don't think the fact that we didn't have evidence sufficient to show an actual damage doesn't mean that the standing doesn't exist. The standing still exists.
What evidence do you have that demonstrates that the credit reporting agency actually understood the creditworthiness of the information from LVNV funding shared about Thomas?
Sure. The evidence in the record demonstrated at the summary judgment stage that we had credit reports, which the court considered that showed that there was no dispute on February 3rd, and then we had credit reports showing that on March 3rd they included the dispute. That demonstrates understanding. The reason it indicates understanding is both Woods and Ewing point out is that they included the representations by LVNV in the credit report itself.
So you had the credit report from February 3rd and the credit report from March.
Yes, Your Honor.
And one showed no dispute, and then the one coming after it showed a dispute.
Correct. So it demonstrates that the credit reporting agencies, at least TransUnion, understood that the dispute itself was significant. We also had evidence that during the time period when there was no dispute, TransUnion disseminated the information that was on the credit report to both Equifax and Experian, and to 3 potential creditors. There's Clarity Loans and 2 others, I can't remember, but they're essentially payday lenders. So all of this it demonstrates that, if they had reported a dispute, TransUnion would have included it in the credit report in February, and then when they communicated to Experian and Equifax and the creditors, they would have included that dispute. That demonstrates a harm to Ms. Thomas. I want to point one thing out about this issue about whether or not Ms. Thomas disputed the debt. This court has held, even in Evans, that Section 1692E8 does not require an individual's dispute to be valid or even reasonable, just that they dispute it. But there's been a misrepresentation in the testimony about Ms. Thomas's testimony. Her testimony was that she actually attempted to return 2 items that she was charged for, and those items were, and she did not receive a credit. So she paid all the amounts that she alleged that she owed, and then refused to pay the parts that she didn't receive a credit for because WebBank Fingerhut refused to give her a refund. So the dispute was legitimate. And under 1692E8 in Evans, it's not even required that it be legitimate. Unless the court has more questions, I think I've made my points.
Thank you. Mr. Newberger, anything further?
Yes, Your Honor. I want to start by noting that no credit report came in at trial. There was no ability to authenticate a credit report. There was no sponsoring witness. There was no deposition of a consumer reporting agency. There was no evidence at trial of the contents of the report.
Right. Probably as a consequence of Judge Bucklow's bar order, as Judge Easterbrook has noted, which was one of several motions in limine that were litigated in front of 2 different judges, but she being the original one who entered the bar order, that because there was no evidence of actual damages produced, that issue was foreclosed at trial, and apparently nobody understood the jurisdictional significance of that ruling.
Your Honor, I'd like to think we did. Respectfully, here's the thing. An order in limine is not an evidentiary ruling. It is an order at the threshold of the case that controls the case. It is the duty of a litigant to ask to approach the court during the trial when necessary and ask the court during the trial to reconsider. In point of fact, what we see during the trial transcript is my friend Mr. McCormick actually acknowledged to the court he needed to get evidence in to show injury. He was unable to do so. He had no sponsoring witness. He could not attest. He had no one to attest to the consumer report. And, you know, we sat there wondering how he was going to do it. Admittedly, Judge Bucklow never addressed the understanding of the information issue that's addressed in Ewing. With respect to her, she kind of slid by that and never mentioned it once in her order. But here's the thing. Getting a summary judgment and showing standing at the summary judgment stage doesn't do it. Because in Lujan versus Defenders of Wildlife, the Supreme Court said standing must be established at every stage of the case and at trial by evidence. If that's not the case, district courts would be trying cases where standing had been lost. I've been doing FDCPA cases for my entire career, first as a plaintiff's lawyer and then as a defense lawyer. I've seen this. You could have a plaintiff who had standing, filed for bankruptcy, did not disclose her cause of action, case is closed and discharged, she doesn't own it. My time is up, Your Honor.
You can finish the thought.
Thank you, Your Honor. The same thing would be true with a class action where the plaintiff is a member of a class, doesn't opt out, and is subject to a class release. She loses her claim, and I've litigated that situation. It is critical that the plaintiff show standing at every stage because it could be lost, and district courts cannot be trying cases where they lack jurisdiction. I thank you very much.
Thank you. Thanks to both counsel, the case is taken under advisement, and we'll move to our next case this morning. United States against Manuel Acuna Diaz. Ms. Sostock, good morning again.
Good morning. May it please the court, Aaron Sostock on behalf of appellant Manuel Acuna Diaz. In this instant case, Mr. Manuel Acuna Diaz entered a plea of guilty to 1 count of illegal reentry of a deported alien. As part of his sentence, the district court imposed a 1-year term of supervised release, despite the fact that the applicable sentencing guideline provides that courts ordinarily should not impose a term of supervised release in a case involving a deportable alien. Additionally, the comment note for that guideline goes on to explain that supervised release is unnecessary unless a defendant is able to return legally to the United States, and it says that if such a defendant illegally returns, the need to afford adequate deterrence and to protect the public ordinarily is adequately served by a new prosecution. Despite the guidelines, in this case, the court imposed this 1-year term of supervised release, and in doing so, the only reasons that were given for imposing this term were the fact that Mr. Acuna Diaz was his illegal status, and that he was likely to be deported as soon as if he was released, and he would be deported if he tried to re-enter. The reasoning given by the trial court was a procedural error because this rationale directly contradicts what the statute what the statutory guidance is with respect to this. The court did not rely on either deterrence.
What effect do you think the word ordinarily in the guideline has? It must mean that there are some non-ordinary cases where supervised release is appropriate. You seem to be arguing that there can't be any cases where it's appropriate. I'd like you to address what the ordinarily word is doing.
I agree. The ordinarily word is doing work, and I think that the committee comment on that actually elaborates on when it is appropriate to impose supervised release on a deportable alien, and it specifically says if the court determines that it's necessary for an added measure of deterrence or protection of the public. Now, in this particular...
Now, of course, the district court in this case said exactly those things. So I don't know what you can do with the guideline. You can say that the district court is clearly erroneous in saying those things. I would understand that. But I don't see what purchase you get just from the language of this note.
Well, the district court needed to justify its reasoning for going outside what is ordinarily done with deportable aliens. The guideline says that ordinarily deportable aliens should not have supervised release imposed, and it's not the case that the judge couldn't impose supervised release in this case, but the judge needed to provide an actual reason that comported with the purpose and the direction given in the guidelines.
Yeah, but my observation is the judge said those things, and you don't seem to be arguing that the judge was clearly erroneous in believing those things, that an extra measure of deterrence was appropriate.
Oh,
As I say, if you think he was clearly erroneous, please, by all means, go ahead and argue that.
I think the confusion is that I disagree that he did rely on deterrence here. I actually think that the court did the opposite of relying on deterrence. The court actually presumed that Mr. Acuna-Diaz would re-enter the country. He did not assume that this supervised release provision would help prevent that from happening and go towards showing Mr. Acuna-Diaz that there would be consequences for re-entering the country illegally. That's not what the judge was trying to do. The judge actually said that he basically said, I'm assuming Mr. Acuna-Diaz will re-enter, and when he does, this will provide a much more expedient way for the government to prosecute him. And that is, I believe, I guess to your question, the reasoning is erroneous.
Why isn't it better construed as an explanation by the judge of why the supervised release would be a deterrent to reentry?
I'm not sure that, because I believe that's just contradicted.
It easily admits of that alternative understanding.
I understand that there is a definitely different interpretation of what the court said, but I
so if there's an interpretation that makes it proper, wouldn't we defer to that?
I don't think that based on what the court specifically said with his assumption, the court's assumption that Mr. Acuna-Diaz would return into the country, that is what he said at the very end of the sentencing hearing. He said, I fully expect, and that is a direct quote, I fully expect Mr. Acuna-Diaz to return. And so that's not deterring. That is actually acknowledging.
Based on his history.
Yeah, and I agree. That's what the court
And so the judge
assumed.
was explaining what would happen if he did.
The judge was explaining
In an effort to deter him from doing it. I guess we would be up to 4 times, or would it be 5?
I'm not sure, Your Honor. I do. I see where you're coming from.
This is easily the language of deterrence.
I see
an
where you're
explanation
coming
of why the judge was seeking to deter reentry by imposing a term of supervised release with immediate consequences for reentry in the form of revocation.
So, Your Honor, I do understand what you're saying, but I don't think what the court was doing was in the spirit of deterrence. His wording, I believe, shows that it wasn't. What he specifically said is, the defendant is going to be deported when he is finished with his federal sentence. There's no doubt about that. So the unlikely event, it's unlikely he will ever be supervised. The purpose of supervised release is for the defendant to be supervised. And so the court has
the whole rationale for the guideline directions for how to handle supervised release in this context is that supervised release should be imposed as a deterrent to reentry. Not because anybody expects that the defendant is going to be supervised. So the judge was just paraphrasing the rationale for the guideline.
The judge then did go on to say, however, the judge's personal rationale in this case, I do not believe went to deterrence. The rationale seemed to rely on the expedience of government prosecution and the fact that Mr. Acuna-Diaz could be immediately immediately detained, and instead of having the government need to refile another charge against him, which I believe contradicts exactly what is in the committee comment, where the comment and the guidelines acknowledge that a new prosecution serves this exact purpose already. So there's quite a contradiction between what the judge actually said on the record and what the committee comment and the guidelines are advising courts to do with respect to these types of cases. Because the court relied on the reasoning was for expedience of prosecution, not because he thought there was any chance that this would actually deter Manuel Acuna Diaz. He actually acknowledges this won't deter Manuel Acuna Diaz. So I do believe that there's quite a contradiction in the words that were said on the record and the reasoning that was said on the record and the committee comments. And for that reason, I would just ask this court to vacate Mr. Acuna Diaz's supervised release and remand the matter for further sentencing.
Thank you. Ms. Aronoff?
May it please the court, Jen Aronoff on behalf of the United States. The district court committed no error in sentencing defendant to a 1-year term of supervised release. The sentence was procedurally sound and substantively reasonable. The court articulated a reasoned basis for imposing the sentence, deterrence, and the need to protect the public based on defendant's criminal history. And the court was permitted by law to impose such a sentence, which was at the bottom of defendant's guidelines range. Turning to the procedural soundness, the district court adequately explained the sentence. The court explained that while defendant would likely need to be deported following his imprisonment, supervised release was necessary to deter him from returning to the United States and committing more crimes. The district court was clear that this sentence was driven in large part by the defendant's multiple illegal entries and his prior commission of drug offenses while in the United States. This was a sufficient rationale to justify a term of supervision, especially where the guidelines explicitly instruct district courts to consider imposing supervised release on deportable defendants when such a term would provide an added measure of deterrence and protection based on the facts and circumstances of the particular case.
One of the factors that the court was able to consider was the history and characteristics of the defendant. Looking at the sentencing transcript in context, I'm paraphrasing here, did the court seem to be primarily focused on the activities that the defendant engaged in when he was here in the country?
The court was very concerned about that, as the sentencing transcript makes clear. I think the court was particularly bothered by the drug offenses that the defendant had committed. And so that actually goes to the second rationale beyond deterrence that underlies this sentence of supervised release here. It's also to protect the public. The court, I think, was specific in the transcript in saying that if defendant were to return to the United States, he expected that the defendant would break drug laws again. So, and that's at pages 47 and 48 of the sentencing transcript. And so protection of the public was an additional rationale there. Your Honors, the sentencing transcript makes clear that the court had thoroughly reviewed and analyzed the defendant's record. He felt strongly about it. And the language, to Chief Judge Sykes' point, clearly goes to deterrence. In fact, the court said at page 49 of the sentencing transcript that specific deterrence really matters in this case because you've never been able to follow the law up to now. I think based on the defendant's history and characteristics, there was a concern that he would want to return to the United States, but consistent with the guidelines, the imposition of supervised release was intended to provide that added measure of deterrence to help him understand what the consequences would be if he were to try and return unlawfully once again.
And Judge Durkin specifically tied that deterrence rationale to the defendant's history of repeatedly re-entering the country unlawfully to address any doubt that the previous 14 pages of transcript somehow disconnected his earlier statements about the term of supervised release from his deterrence explanation.
Yes, Your Honor, the district court was quite clear on that point. The threat of
He always imposes supervised release first and then the prison term, apparently.
that is what the district court said, but then at the end, he sort of returned and re-articulated the need for deterrence in this case. Your Honors, if the court does not have any other questions, the government would request that the court affirm the district court's judgment.
Thank you.
Thank you.
Ms. Sostak, anything further? You had a little time left.
Just very quickly, I just wanted to point out that although the district court did talk about Mr. Acuna-Diaz's history and characteristics, but when it came to actually imposing the supervised release term, the court was very clear that the court was not imposing this to actually deter Mr. Acuna-Diaz, because the court assumed Mr. Acuna-Diaz would actually return regardless of whether the supervised release term was entered. The purpose of entering the supervised release term was not deterrence, and that was stated on the record. The purpose was for the ease of prosecution of Mr. Acuna-Diaz when he does inevitably return to the country pursuant to what the court believes will happen. I can't speak to Mr. Acuna-Diaz's motives on my own, but the court was very clear that the purpose of supervised release was not to deter him from returning, but to create a much easier process for the government when he does return, which is not what the purpose of supervised release is, and it's contrary to the guidelines.
Thank you.
If there's no other questions. Thank you.
Our thanks to all counsel. The case is taken under advisement. And our next case for argument this morning is United States versus Brian Broadfield. Mr. Drysdale, good morning.
Good morning, Your Honor. May it please the court. My name is Tom Drysdale. I'm from the Federal Defender's Office, and I'm here today on behalf of Brian Broadfield. The sole issue before the court is whether the district court impermissibly relied on the seriousness of Mr. Broadfield's conduct as the driving factor behind its 16-month revocation sentence. Now, I don't think there's a lot of dispute as to what the law is, at least right now in the Seventh Circuit. 18 United States Code 3583E sets out the factors that can be considered in imposing a revocation sentence, and noticeably absent is 3553A2A. And what this court has said is due to the overlap between the seriousness of the offense and the need to impose punishment with other factors, it can be considered, it just cannot be the driving factor behind the district court's sentence. So the question that is before the court today is, when we look at what the district court said in imposing sentence on Mr. Broadfield, was his conduct or the seriousness of it the driving
The Supreme Court has granted certiorari to consider whether our decision in Wiltshire, which is what you're referring to, is correct. Should we wait for the Supreme Court's decision in Esteros?
I don't think so, Your Honor, because we believe, at least at the moment, under the court's current precedent, that Mr. Broadfield can prevail because this sentence was...
Of course, you don't discuss this court's most recent precedent on this subject, which is the Townsend case. Your briefs don't mention Townsend, although one would have thought that was pretty important.
Your Honor, I think in the briefs, we mentioned a myriad of cases that this court has decided on this issue. Wiltshire, Martin, and several other cases that this court has dealt with, and looking at the court's precedent being, was it the driving force behind the district court's sentence? And I think that's the question that we need to answer today, and I think when we look at what the district court said in imposing the sentence...
The initial question I asked you was whether we need to answer any question. Esteros will be argued in the Supreme Court in 2 weeks. Should we wait for it? Why should we decide something under Seventh Circuit precedent that may not be long for this world?
Your Honor, you shouldn't wait for it, because the answer is either this court's precedent is going to be upheld, and the driving force analysis is going to be correct, or the court will have not been allowed to rely at all on 3553A2A.
Oh, no. You are obviously not acquainted with the briefs in Asteris.
I am, Your Honor.
Those aren't the only two options before the Supreme Court in Asteris.
I understand that, Your Honor, but the other reality for Mr. Broadfield is that he's going to be released from custody in May. And so looking at his availability for any real relief, it's highly unlikely that Asteris is going to be decided prior to his release from custody.
Okay, that I understand. That's a better reason. Thank you.
Certainly, Your Honor. And so looking at the merits of this case, we look and we see that the district court relied almost exclusively, if not exclusively, on the seriousness of Mr. Broadfield's conduct. Starting right off the bat with the district court seeming to acknowledge that it has never heard of the argument that 3553A2A is not part of the revocation sentencing process. And then doubling down and saying that it cannot impose a revocation sentence without considering 3553A2A because it's, quote, absolutely bedrock. Then we look at the transcript at 52. The district court said what you did here was very, very serious. Then we go to 54, where the district court goes on for an entire paragraph about the seriousness of the conduct. He calls it really bad. The district judge then details everything Mr. Broadfield did the night he was arrested and finishes up by saying, oh my, that's bad. And even in acknowledging Mr. Broadfield's allocution statement, the district court immediately returns to the offense conduct.
Could you perhaps now come back to Townsend? Because we held in Townsend that when a district court recites the facts and circumstances of the offense and says, oh my, that's bad, there isn't any problem under Wiltshire. And you seem to be saying there is a problem under Wiltshire. Do you think we should overrule Townsend?
No, Your Honor. And I think that standing alone with the district court reciting the facts of the offense and saying, oh my, that's bad, that alone doesn't create the Wiltshire error or an error under Townsend. I think what our point is when you take that, you combine it with the other things that the district court said or miraculously did not say, combine it with the government's argument, which only focused on the seriousness of the offense, then that puts us in a situation where we have a Wiltshire error. And that's precisely what the government is trying to do here on appeal, is what this court said was not okay in Wiltshire. The government is trying to come up with belated explanations for the district court's statements that appear, frankly, nowhere in the transcript. The government says in its brief that, quote, Mr. Broadfield's lack of response to probation's efforts to assist him hindered the goal of deterrence, which in turn had public safety implications. That's the government's brief at 29 to 30. That's absolutely nowhere in the transcript. Those are the government's words, their explanations. The government also claims that the district court concluded that Mr. Broadfield's conduct was, quote, inextricably intertwined with other permissible Section 3553A factors. Again, the district court did not say those words. That's the government coming up with explanations that aren't in the transcript. In fact, the court said the opposite of that. It was not aware that 3553A2A was excluded, and in any event, it cannot impose a sentence without considering it. And in fact, the district court at the end, when trial counsel preserved this argument for appeal, went a step further and openly disagreed with the omission of 3553A2A from 3583, saying, quote, with all due respect to the Congress of the United States, the court could not impose a sentence in this case or any case without considering the seriousness of the offense. So I think when we look at the words, we look at the government's arguments, we look at the district court openly disagreeing with the exclusion of this factor from 3583, I think this puts it in the world of Wiltshire, where there is just nothing in this record that can be gleaned from the transcript, from the district court's words, to show that the driving force was not the seriousness of this offense. And I think that's the last point I want to make before I reserve time for rebuttal, is it does not have to be the sole consideration. It must be the driving force. So I understand that the district court does make some other statements that frankly aren't really tied to anything, like statements about mental health treatment and statements about Mr. Broadfield's attitude. But the court never says, and your attitude leads me to believe that the public is at danger or anything like that. It just says it reflects a certain attitude. So when we look at this whole record, I think it's pretty clear that the driving force behind this sentence was the seriousness of Mr. Broadfield's conduct. If the court has no more questions, I will reserve my time.
Thank you. Ms. Boyle.
Good morning, Your Honors. May it please the court, counsel, my name is Catherine Boyle on behalf of the United States. The district court here didn't procedurally err in sentencing the defendant to a below-guideline sentence of 16 months. Listening to the defense counsel's argument today, it sounds like at certain points we are looking at a different transcript. Here, the transcript shows that the court relied on permissible factors in sentencing the defendant. Although the court discussed the seriousness of the offense, the sentence largely turned on the defendant's violation of the court's trust, which it described as a major consideration, and other permissible factors. That was appropriate, as this court recognized in Townsend, and as the district court recognized here in saying that the seriousness of the offense was in some respects bedrock. It is practically impossible to separate the seriousness of the offense from things.
Ms. Boyle, I'd like to ask you the same question I asked your adversary. Should we wait for Asteris, since the Supreme Court has this issue before it?
Your Honor, I think it could be wise to wait for Asteris. The Supreme Court does have this issue before us, and they're making a number of wide-ranging arguments in the Solicitor General's brief. I do recognize that Mr. Broadfield in this case has a release date in May 2025, and that may be a reason the court would choose to continue anyways.
Okay, thank you.
You're welcome. So it was appropriate for the court, given what we think is appropriately described as the inextricable intertwinement of factors like seriousness of the offense with the nature and circumstances of the offense, respect for the law with deterrence. This is a situation where when you look at the transcript, the district court may not always use the exact word deterrence, but the district court very, very clearly articulates that that is one of the things it's concerned about. It says the defendant has mental health problems, but he's declined to get treatment. Probation is attempted multiple times. I'm not sure what else we can do about this, and notes that he's concerned that the defendant's behavior is going to continue without addressing these mental health problems. The court says on page 55, I'm concerned about what you'll do in the future. That goes to protection of the public, it goes to deterrence, it goes to all of these factors that defense counsel is saying that the district court didn't consider. The court notes Mr. Broadfield's statement.
Was the judge also able to consider the nature and circumstances of the violations?
Yes, Your Honor, I believe so.
And did he consider those as well?
Yes, I believe that's one of the reasons the court in this case did spend some time. And here it's interesting. The nature and circumstances of these violations they were intertwined also with this deterrence idea, in that the violations here included resisting arrest. The violations here included flooding a holding cell that then flooded into the booking area of a jail. The defendant then had to be carried from this holding cell to another cell where he urinated and smeared feces under the door. And this was 7 hours after the defendant had stopped drinking. The government presented an audio recording of a phone call at this where the defendant exhibited a lack of respect for law enforcement and used a number of pejorative words and swear words. And this does overlap with the idea, can you obey the law? Can you obey your conditions of supervised release? Are you going to be a danger to the public in the future? Can we deter you from this criminal conduct? And as the court also appropriately recognized when raised by defense counsel during the hearing, it matters the nature and circumstances of the offense and the seriousness of the conduct is correlated, as this court has recognized in multiple prior cases like Clay and Martin. It's correlated with the severity of the breach of trust that the court has in the defendant to follow these conditions of supervised release. The court has on a number of occasions recognized that the district court may consider the seriousness of the offense given the overlap So has the Sentencing Commission, which has directly said the court should sanction primarily breach of trust while taking into account to a limited degree the seriousness of the underlying offenses. Here, the seriousness of the offense was so overlapping with these other factors, nature and circumstances, deterrence, that it was not possible, as the court recognized. And the court correctly recognized that it was permitted to consider the seriousness of the offense in its sentencing. That is completely affirmed by this court's case law and was not an incorrect statement of the court's discretion. If your honors have no further questions, the government will rest on the arguments in its brief and ask that the court affirm.
Thank you.
Thank you, Your honors.
Mr. Drysdale, anything further?
Just briefly, Your Honor, to touch on 2 points. The government's really hanging its hat here on the district court's discussion of mental health treatment that Mr. Broadfield didn't accept from probation. But there's no discussion by the district court of what permissible Section 3553A factor that ties into, and the government cannot make it up from the record. That's Wiltshire. The district court simply says that Mr. Broadfield has mental health problems and that probation tried to help him, and then just concludes that says Mr. Broadfield has an attitude. That's it. The court doesn't say that suggests that you're dangerous to the public, that suggests that you're going to do this again, that suggests that you're going to violate your next term of supervised release. It just says, it suggests to me that you have an attitude, and then the court turns around, I think, and ties that attitude back into Mr. Broadfield's conduct. So again, to go back to Wiltshire, the court would have to indicate how that attitude interacts with a relevant sentencing factor, which it simply didn't do. And to the government's point about how the district court, just because I think at one, possibly 2 points, used the term breach of trust, number one, it wasn't until defense counsel used that term. But number two, if you look at the transcript at 52, the court talks about how it imposed the original term of supervised release to build trust over time. And that, again, right there is the court conflating the purposes of an original sentencing and its permissible factors with the purposes of a revocation sentence and what you can and cannot do. So the fact that the court, and this is this court's opinion in Dawson, the fact that the court used the term breach of trust means very little if the record shows that the court did not actually apply that theory. So we ask that this court reverse and remand for resentencing. Thank you.
Thank you. Our thanks to both counsel. The case is taken under advisement. And our last case for argument this morning is United States versus Cannon.
Good morning, Your Honors, Counsel. Just under the wire on the morning. May it please the court. My name is Joanna Christensen and I represent the appellant Marquise Cannon. The district court erred by finding a life term of supervised release was mandatory in this case. The court said, as to this term of supervised release, it has got to be life. So the term of supervised release will be life. Now, if the court had done any other findings regarding the range, either
Ms. Christensen,
yes,
there are obviously two possible understandings of that sentence. One is it's got to be life, means the law requires me to impose life. The other is it's got to be life means the facts require me to impose life. You ask us to assume that the district judge took the legally erroneous meaning. Why shouldn't we assume that the district judge took the one that's consistent with the law?
I think that because the court made no efforts to determine that there was a range. So when the court's considering all of the reasons for the sentence, if the court had simply said, this is a range of 5 to life, and based on these facts, it should be life. It has got to be life. But the court didn't make that finding. The range is not mentioned in the sentencing transcript. And all the court says is it's got to be life. So
the judge mentioned the correct range multiple times in this case. Do you think his memory is so faulty that he didn't remember?
The judge, my reviewing of the transcript does not show that he mentioned the 5 to life. He said at one point that the maximum was life, but doesn't talk about the range itself as to why that is life.
Well, the reference to the maximum of life implies other options less than the maximum. If the range were life, he would have said that at the sentence or at the plea hearing, the change of plea hearing.
Right.
He would have said, you're going to get life supervised release no matter what.
I think it's definitely unclear, but when there's no mention of a range at all, that's the problem here, is that the mandatory feeling is the life. And that language is nearly on all fours with the Wiley case, which is what we're relying on, where in Wiley we have all these other factors the government's trying to rely on, that it was correct in the pre-sentence report. It was in this case, it was in Riley. The district court adopted the pre-sentence report, here, this case, and in Wiley. And the court asked defense counsel if there were any objections to the sentence, and defense counsel said no. And Wiley, again, reversed on plain error. There's a slight difference in the language. The district court did use the word mandatory in the Wiley case, and not here. But the language is the same that the court used, is that as to a term of supervised release, it has to be life. So taking the district court at its word, that is the assumption that it's mandatory life. And in other cases, as we've cited in our briefs, that's enough to meet the plain error test here. And the term, it's not, as the government argues, any problems with the district court's findings. You know, the district court's findings about the appropriateness of the sentence can go toward the appropriateness of the term of supervised release. The argument here is the district court assumed that supervised release was mandatory, or the term of supervised release was mandatory life. And that's the issue here. So, and like in Wiley, this case should be remanded. In Wiley, it was a limited resentencing to ask the district court, is this what you meant? You know, what would you have done if you had known the correct thing? And I believe the same remedy is appropriate here. So unless the court has further questions, I will reserve the rest of my time.
Thank you.
Thank you.
Mr. Kerwin, good morning again.
Good morning again, Your Honors. Brian Kerwin for the United States. Your Honors, as Judge Easterbrook's question alluded to, the court was not confused as to the mandatory minimum term of supervision that it was required to impose in this case. The sentencing transcript makes clear that the court's statement, its one-off comment that it has got to be life, was a reference to the 3553A factors and the facts of this case compelling that result. And we see that both before and during the sentencing hearing, as well as afterwards in the court's statement of reasons. The court stated the range correctly at the change of plea hearing. It made clear at the beginning of the sentencing transcript that it had reviewed and then adopted the PSR. The PSR contained that accurate range. That this court's case law has held that information is imputed to the district court. And throughout the hearing, both defense counsel and the government were speaking the same language as the court in terms of whether a range applied and what that mandatory minimum was, and the fact that it was not life. The court explicitly said that there was a minimum term that would apply. Separately, as Judge Sykes commented, it said expressly that there was a maximum of life. Defense counsel acknowledged that the court would impose supervised release for a period of years that it would determine. The government made a strong argument for the imposition of a life term to ensure that the defendant would be fully rehabilitated, that the victims would receive restitution. And if there were any doubt that the parties were speaking the same language, the court asked both counsel for the government and defense counsel almost immediately after making its got to be life statement whether it had committed any procedural errors. Defense counsel flagged two with respect to the mitigation explanation that the court had provided. It did not identify this particular error, and in the government's view, that was a waiver of this particular procedural claim. But even if the court were to find that that was not precise enough, given the breadth of the court's question.
Counsel,
yes, Judge.
When you're arguing waiver, what do you think is the effect of Criminal Rule 51A?
The effect of Rule 51A, as this court judge has made clear many times recently, including in the Martin case, is that an error that arises in the course of the court's explanation does not require an objection to receive de novo review.
Does not require an objection.
Correct.
Rule 51A says you never need to argue with the judge once the judge has ruled.
Agreed.
And here you are saying that the defendant waived his position by not arguing with the judge after the judge ruled. I think not only is Rule 51A clear, but Martin was very critical of the United States for making the very argument that you are now reiterating. What do you think we should do?
I disagree with the upshot of Martin that you're articulating, Your Honor, insofar as Martin, the government, argued that plain error applied because the defendant did not interrupt the judge and raise that objection in real time. But there's a separate line of cases that have not been unwound, Garcia Segura, Lickers among them, that if the court prompts counsel with a specific enough question such that the answer evinces a deliberate and conscious choice not to pursue that particular challenge, here, quibbling with the word choice, it's got to be life, which was made moments before the question was asked, then a waiver can still apply with respect to a procedural error. And so you've got the Martin cases in the 51A space that you're alluding to, Your Honor, but then you've also got the opportunity for waiver to
let me be sure that I understand your argument. It is that if the judge invites responses, actually the judge has compelled responses, because if you don't accept the invitation, you've waived. Is that the government's argument?
The government's argument is if you accept the invitation, you've waived. If the court asks, have I done something wrong in this particular way, and defendant says, no, you have not, you cannot raise that issue for the first time on appeal because you've evinced an intentional relinquishment of a known right by answering a precise enough question, as we see in Lickers, and expressing that you have no objection to what the court has done. And so you've given the judge an opportunity to correct it, or you've taken away the judge's opportunity to correct it by telling he or she that he's done nothing wrong. So that's the government's view, Your Honor. But as I said, even setting the waiver question to the side, that question and answer between counsel and the court underscores that it was the predatory and repeat nature of the conduct that compelled the judge's sentence, and that all the parties were speaking the same language during the sentencing hearing. So unless there are any other questions from the panel, I'll ask that the court affirm the sentence imposed by the district court.
Thank you.
Thank you.
Ms. Christensen.
I will take a few minutes to address the waiver issue because in addition to Martin, which is a relatively recent case that was decided after briefing in this case, Wiley talks about this exact issue because it came up. Now, Wiley doesn't mention Rule 52A, in any case, but finds that was not waiver, specifically rejects the government's argument about waiver. So that should not be waiver here. It should be plain error under the Wiley case. We're reading the entire transcript shows that the district court never talked about there being a minimum term, only talked about the maximum of life, and didn't fully consider the range and thought the life was mandatory. So unless the court has questions, I'd like to ask the court to reverse and remand.
Thank you.
Thank you.
Our thanks to all counsel. The case is taken under advisement, and that concludes today's calendar. The court is in recess.